order.
The petitioner
Well, I'll let them do the order
appears
when they
by
decide
Zoom,
for sure.
along with her
If
attorney,
there's
Ms.
someone
Mindy
else that
Wheeler.
they
The
can agree upon
respondent,
that
is he in your
prefer.
office?
So
No, ma'am. It's just me today.
Ms. Brammer, I'm
Okay.
going to have you do the order.
does
for
not appear,
mediation.
but appears through
And then go ahead
counsel.
and do
Ms.
the
Brammer.
child support adjustment order, please. And there's been a motion that's been filed. Today's just kind of a status, but basically.
Also, Judge, can we get some hard
um,
deadlines in the case as far as
Dad
a
has
deadline for
filed
us
to
to get
modify
mediation
custody
Yes.
scheduled
parenting
and in
time,
and then back in front of
and
you?
then
Yes.
child support
Um,
accordingly.
I always prefer to do
Requesting
them before school
a
starts.
week
but
on, week off
for sure 90
situation.
days.
I'm always of the
the kids are
opinion
17 and
that
14.
if an agreement can
believe,
become,
if they can come to an agreement,
and so they're
it can happen
teenagers
within 60 days,
90
days at the most.
and there's
Otherwise,
been a proposed
they're not agreeing to anything, and
permanent
more issues
parenting
the longer
plan.
they're in mediation setting, the
Um,
more issues that get brought up, and the
so
more issues that develop, and
unless
it's
there
not
is a legal
very,
reason why this
productive
motion
at some
cannot
point.
or should not
So
be
I would say
considered,
let's check how things
I
are
think
going.
this is probably a
in
case where
August. I will ask that it go to
I have a
domestic
domestic day,
conciliation.
August 11th.
That's
um,
not quite
Probably with
60 days,
collaborative
but
out of
close.
Andover. That's the first day of school, I guess, in El
And I will
Dorado.
tell
I
you
don't know
one
about
of
my
Andover,
thoughts, but
but-
I'll hear from both of you. But one of my
There's no
thoughts
issue.
is,
Again, I'm sorry. Sometimes
I need
these
to
cases
know the
run
kids'
together because I have
schedule, their thoughts.
one case where
how things
mom's
go at
living
each
in
household,
Rose Hill,
their grades, their all of those.
there was some issue with
types
that
of things.
but
There is no issue with
what school
So,
the child's going to
I
go
mean, I
to
will
in the
expect,
fall,
Ms.
correct?
Brammer, that your client has
Correct, Your Honor.
exercised
one of- if
all
I could-
visitation
Daniela,
that he was
I'll
entitled
answer.
to, and then
Thank you.
some.
No, there's not
sort
there's
of
not an
has
issue
gone
with the
above
school
and
choice. The
beyond
school at this point
if
in
he's
time, that's not been
asking
raised.
for
Changing the child's
shared.
school.
Now, I understand the
Okay.
response is
All right.
mom's paid for
So,
everything.
We
Mom
can't.
is
we
the
don't. It's not
primary,
like we have to have something done before school
caretaker,
starts, which
provider,
a lot of these
organizer,
cases, it seems to be
and all of
an
those
issue.
types of things.
So, what about the 11th? And
August
I
11th work.
I looked at
for
a number
either
of
one of you.
cases.
If
I have
not, what I
a case
would be
about every
looking
half
at
hour
is,
today. I think
This is the one that
the
other
31st
thing
of
I'm
August.
concerned about
So,
is
those are your
mom's
choices:
income.
11th or the 31st.
If she's not working,
August 11th works for
Um,
me.
Works for me as well, Your Honor.
is
Okay, I
relatively
only have settings at 1 and 2.
low.
So,
Do you want to do 9 o'clock in the morning again? Does that
Uh,
work well, or
so
a different time? Going from
I mean, the afternoon's fine.
$2,300 or so in
if those
child
are the only
support, or
settings you
whatever
have.
it is now.
I'm not picky.
down
no,
to
I mean, I
6
only have
is
2
quite
already set that are
significant.
taken up, 1 to 3.
And would
Otherwise, I have
certainly
all morning.
Oh, okay.
Change the
to
kids'
5
standard of living,
open
I
right
would
now.
imagine.
Gotcha.
But having
okay.
mentioned those
9's
things
fine
and
if it's fine with Miss
my
Wheeler.
thoughts and my belief
It's fine
that
with
this
me.
is
Okay.
actually a very
All
appropriate
right, we're going to
case
set this
for
for review.
potential
on,
investigation.
DC
Certainly
on August the 11th.
mediation. I want to hear from council,
Are there
starting
any other
with
dates
you,
that
Ms.
you
Brammer,
would
since
like?
it's your motion.
Ms. Brammer?
Yeah. One of the
Getting
kids has
scheduled
actually
within the next
turned 18
30
All right,
at this point.
guys.
Do
This
what?
custody
A
dispute
requirement
opened
that
with
we
both
have
sides
something
appearing through
scheduled within
legal
the next
counsel
30 days.
as the judge reviewed a
Oh,
newly
I
filed motion
like
that
the
could dramatically
motion scheduled in the
reshape
next
the
2
family's
weeks.
future. The
Next 2
father
weeks.
is
Okay,
requesting a
better for me.
major modification
that
to
they've made
custody,
Keep it rolling.
asking for a
with
week on,
whoever you
week off
guys have
parenting
agreed
schedule for the
upon,
couple's teenage children,
or
ages
in the
17 and
alternative, the
14.
one that I
Before making
mentioned,
any decision, the
if
judge
you can't.
emphasized that shared custody requires much more than a
Okay.
simple request.
Yep.
The court
All
wants
right. If
detailed
there's nothing
information
further
about
today,
each
we are
child's daily
adjourned. Thank
routine,
you.
academic performance, stability, and life inside both households. Questions were also raised about whether the father has consistently exercised every parenting opportunity available. As the hearing continued, it became clear that this case wasn't only about custody. It was also setting the stage for a serious financial dispute that could impact everyone
Has actually
involved.
turned 18 at this point.
That's true.
And graduated high school as well.
Okay.
So one of the things we wanted to accomplish today was to address child support, at least on a temporary basis, given that there's no reason for child support to continue for that specific child. And right now, my client's going to be paying for both kids until we have an order from the court. So I have talked to Miss Wheeler, and we haven't been able to agree on income. We did exchange some documentation and discuss what my client's income is, but we weren't able to reach an agreement on the figures. So we kind of came up with a temporary band-aid to at least like staunch the money bleed from my client's side to avoid significant arrears. And if I'm misstating, please correct me, Miss Wheeler, but basically we agreed to use the current reported income and insurance costs. Basically, the worksheet that's on file for the current costs, but removing one of the children. So we'll use currently accepted figures, but remove the eldest child. And we also couldn't agree on a commencement date.
I thought it's June 1.
Yeah, that's what my position is, but we had a disagreement about doing it on July 1st. That would be obviously my preference is June 1, but
Well, this is almost by operation of law, that it terminates. But Ms. Wheeler, what is your position? It makes sense to me if you still need figures or you need to argue about, imposing some kind of wage to mom, imputing it, that we at least look at where the last child support worksheet is and remove one of the children.
Your Honor, yes, Miss Bramer is correct that we had discussed entering a temporary order and reserving any disputes we may have about the numbers going into the calculation, but definitely removing the oldest child. Our position is that the new support date would start July 1st. Our reasoning for that is that the current order that's in place, and there have been several orders regarding child support filed in this matter over the years, and they have always maintained that it would terminate as of June 30th. It's specifically stated in the last child support order and all the prior child support orders that have been filed in this case. So my client was reasonably anticipating a termination of this support obligation as of June 30th. She does have costs associated with this child and the other child, and I would ask that the court make the temporary modification effective July 1st, and then if counsel can't agree to make that effective June 1st, then we can take up that basically half a month's child support when we do have our final hearing in this matter. But I believe the last child support order, I don't have it in front of me, I apologize, was filed in mid-2025, and it maintained that same language that child support would terminate as of June 30th of the year the child turned 18 and graduated. And again, that's what my client was reasonably anticipating, that termination date for Brianna, the oldest child's child support.
Okay. Would you agree with me though that June 1st is usually, I need to look at the statute again, but isn't that statutory?
But here's where the courtroom conversation took a dramatic turn. One of the children had already reached adulthood and graduated from high school, immediately raising questions about whether child support should continue for that child. The father's attorney argued that ongoing payments were creating unnecessary financial pressure and proposed an immediate temporary adjustment, while the remaining disagreements were sorted out later. The mother's attorney agreed that the oldest child should be removed from the calculation, but insisted the effective date should follow the existing court orders rather than the father's preferred timeline. Suddenly, the debate shifted away from parenting and focused on statutory deadlines, previous rulings, and whether long-standing court orders should outweigh more recent legal standards governing when child support obligations officially change.
Statutory?
Yeah, I would actually have to go back and look at the statute as well, I believe. And I was discussing this with my client at some point in time, and considering this, but I believe that in the past it was June 30th because that's what I have always used until up through 2020 when we entered these orders originally. And I do believe that now moving forward, we look more at June 1st as the obligation, the date to change the obligation. But my position in this case is that it has always been in the court orders as June 30th would be the termination date. And that's, again, what my client reasonably anticipated for support.
Okay. Well, I guess I just have to kind of hear some testimony as to why this, why there would have been some consideration given for something longer than the law provides for. But let's just reserve my ruling on that, see what you all can ultimately work out, but take the current order and remove the oldest child. So now we're just for week on, week off purposes, we're talking about the 14-year-old. When does a 14-year-old turn 15?
That
I
would be
don't know that.
January. Sorry, that
I'm
would be
sorry.
January.
January.
Okay, so we got some time. So a freshman or going to be a sophomore?
Freshman,
Going to be a freshman?
correct.
Oh, so going into high school. And that's at Rose Hill?
No, that is Andover, Andover
Andover.
Central High School.
Okay,
Your Honor.
Andover Central, okay. All right. Okay, any objection to mediation with collaborative resources?
No, we had already talked about wanting to go to mediation anyway, and I don't really know anything about collaborative, but if it's what you guys always refer to, then that's where we'll go.
Well, I don't think we have a place anymore that is our go-to, always, like a standing order or anything like that. I think generally it's where the parties can agree for me, or I designate, but I do know they tend to do a very thorough investigation if there's not an agreement, including, visiting with children and that kind of thing. But so do a lot of the attorneys that do mediation. So I think for mom, it's going to be a matter of cost. So I guess I'll say, you guys either agree to someone or my order would be collaborative resources in Andover. That's generally how I do it. I get attorneys to agree. If they can't agree, then I have to designate. But they do a good job of getting supportive documents or information. So I do think that they are worth the money if you're going to be spending money on this anyway.
Okay. I'm fine with that.
Okay. So Amy, can we do the order?
Now pay
for-
close attention, because the judge wasn't ready to issue an immediate ruling. Instead, the court questioned why prior orders appeared to extend support beyond what current law might require, and explained that testimony would likely be needed before reaching a final conclusion. For the time being, the judge instructed both attorneys to temporarily calculate support using only the younger child, while reserving all remaining disputes for future proceedings. Attention then shifted back to custody, with the court focusing entirely on the 14-year-old's upcoming transition into high school. Recognizing that parenting arrangements involving teenagers require careful evaluation, the judge encouraged mediation and recommended a comprehensive investigation that would include interviews, documentation, and input directly involving the child whenever appropriate. This hearing ultimately ended with cooperation replacing confrontation. Both attorneys agreed that mediation offered the best opportunity to resolve the custody dispute before a contested trial became necessary. The judge stressed that prolonged negotiations rarely benefit families and directed both parties to begin the mediation process almost immediately, preferably within 2 weeks. Firm deadlines were established, with a review hearing scheduled for August 11th to monitor progress and determine whether meaningful discussions had taken place. Before adjourning, the court confirmed that the child's school placement was no longer disputed, eliminating one major obstacle. Although no final custody or child support ruling was issued, the courtroom left with a clear roadmap toward resolution, and the next hearing could determine the future of both parenting time and financial responsibility.